So we are live now. Thank you, team LiveLaw. Hello everyone. Good evening. Welcome to our third annual Vimukta Diwas lecture in collaboration with LiveLaw. My name is Sagar Soni, and I'm a lawyer and litigation associate at the Criminal Justice and Police Accountability Project, or the CPA project. We have gathered today to mark the occasion of Vimukta Diwas, which is the 72nd anniversary of the repeal of the Draconian Criminal Tribes Act. Today, we are joined by our esteemed guest, Honorable Justice Shri Abhay.S, who will be sharing his thoughts on the Constitution of India and denotified tribes. I want to begin with a short introduction to the CPA project, the Criminal Justice and Police Accountability Project, that was founded in 2020 as a litigation, research, and advocacy intervention committed to ending the disproportionate criminalization of marginalized communities by the criminal legal system. These communities include those previously officially criminalized under the colonial laws, now termed as denotified tribals communities or Vimukta communities, as well as others communities that are similarly persecuted and stigmatized by the criminal justice system. Further, I would like to provide a brief context of the significance of the Vimukta Diwas, the origins of which lie within the Criminal Tribes Act or the CTA of 1871. The CTA criminalized several nomadic, semi-nomadic tribes, among other tribal communities, as hereditary criminals addicted to the systematic commission of non-bailable offenses. Even children from these communities were branded as born criminals. The law provided to the police extensive powers of surveillance, compulsory registration, and taking fingerprints, etc., with no rights accorded to those criminalized communities for questioning these provisions. Post-independence, the Criminal Tribes Act Inquiry Committee, set up in 1949, recommended the repeal of the act as it was deemed inconsistent with the principles of equality and freedom that were championed as the foundation of independent India. The recommendation of the committee further led to the repeal of the act on 31 August 1952, the day which has come to be celebrated as Vimukta Diwas. Vimukta meaning freedom from the power of the city. However, despite the repeal of the act, the stigmatization, systematic criminalization of and discrimination with the Vimukta community still continues through habitual offender provisions across the states as well as other criminal laws. The long shadow of the city is still evident to this day, where this past July in Madhya Pradesh, a young Parthi man lost his life to the custodial violence at the hands of the police on the very day of his wedding. The incident followed by torture of the women and children by the police, custodial torture with the uncle of the deceased. No police officer has been suspended to this day, even as a judicial inquiry has been completed. However, this is not the sole incident echoing the systematic violence that those from Vimukta communities routinely face. Over the last 72 years, a number of members from denotified tribes have lost their lives to being deemed as habitual offenders. We wanted to remember a few of them today. Budan Sabar, a member of the Sabar tribe from the West Bengal who was murdered in police custody. Chuni Kotal, the first women graduate from the Lodha Shabar community who died with a suicide as a result of the casteist harassment at the workplace in 1992. Indra Malwai from Parthi community in Madhya Pradesh who died as a result of the police violence in 2017. Deva Parthi, Atmaram, Israel, Sheru Parthi, all from the Parthi community in Guna, Madhya Pradesh, who lost their life due to the police violence. Vimukta Diwas and CPA project, even today, is an ode to a relentless resistance of denotified tribes as well as collectives and organization of Vimukta communities such as Nomad Liberty Movement, Budan Theatre, Anubhuti Trust, Mazal, and others. We urge you to kindly engage with their work. With this, I'll hand over to my colleague Himanshu, who will introduce our esteemed speaker for the today. Thank you everyone for joining. Jai Savitri, Jai Bhim.
Thank you, Sagar. Good evening, everyone. I'm Himanshu Mehra, a final year student at Nalsa University of Law, Hyderabad, and an intern with CPA Project. It is my honor to introduce Honorable Justice Abhay.S. as a highly respected figure in India's judicial system. As he addressed today's lecture, Justice Oak completed his BSc LLM from the University of Bombay. He began his legal career upon enrolling as an advocate in June 1983, starting his practice at the District Court of Thane in the chambers of his father, Shri Srinivas W. In 1985-86, he joined the chambers of Shri V.P. Tipnis, a former judge and at the Bombay High Court, and a former Lokayut, through which he gained exposure to significant matters, including public interest litigation. Justice O was elevated as an additional judge of the Bombay High Court in 2003 and became a permanent judge in 2005. His judicial journey further progressed when he took oath as the Chief Justice of Karnataka High Court in 2019. Finally, in 2021, Justice Oak was elevated to the Supreme Court of India, where he continues to serve with distinction. Justice Oak is known for his commitment to upholding constitutional values and delivering judgment that have a far-reaching impact on social justice in India. Thank you, sir, for agreeing to deliver this year's lecture on such an important occasion. Without further delay, I would hand over to Justice Oak. Thank you, sir.
Good evening. Founders of the Criminal Justice and Police Accountability Project, the volunteers associated with the project, ladies and gentlemen. This lecture should have been held on 31st August 24. However, it was not possible due to my preoccupation. Many of you know that 31st August is celebrated as Vimukta Zati's Day in India by denotified tribal communities. 31st August marks the day of repeal of the draconian law known as Criminal Tribes Act 1924. This was done by the Criminal Tribes Law Repeal Act 1952. This Repeal Act repealed 1924 Act with effect from 31st August 1952. The Criminal Tribes Act 1871 was the first of such acts brought into force by the Britishers. It was repealed by the 1911 version of 1871 Act. The 1911 version of the law was repealed by 1924 Act. As the earlier speaker has said, 1871 Act was one of the most draconian laws passed during the British regime. Under this law, a very large number of members of nomadic and semi-nomadic communities were declared as criminals. 1871 Act conferred powers on the local governments to recommend to the Governor General in Council to declare any tribe, gang, or class of persons as a criminal tribe. The Governor General in Council had the power to declare a tribe, gang, or class of persons as a criminal tribe. There was a provision to prepare a register containing the names of persons belonging to the tribes declared as criminal tribes. Thereafter, a local government could exercise the drastic power of confining the members of a declared tribe to a particular place. These laws enabled the states to declare a large number of individuals belonging to a declared criminal tribe as criminals without holding any trial. These laws prevented these individuals from leading any kind of a dignified life. In fact, they were kept under constant surveillance, which prevented them from leading day-to-day normal life. Thus, by law, stamp of being criminal was put on millions without any basis. We must remember that it took 5 long years after independence to repeal such draconian law. All of us know that after 31st of August 1952, some of the tribes classified as criminal tribes were included in the list of denotified tribes. Broadly, it can be said that all denotified tribes are nomadic tribes, but the reverse is not necessarily true. 75 years after coming into force of the Constitution of India, the stigma attached to the communities which were branded as criminal tribes under 1871, 1911, and 1924 Acts have not completely disappeared. That is a huge challenge faced by our society and the justice delivery system. The mindset of some of the citizens has not changed. More importantly, the mindset of law enforcing machinery, namely the police, has not changed. It is said that more than 120 million persons have been included in denotified tribes. This shows magnitude of the problem. I had occasion to see some of the FIRs, especially relating to offenses of robbery. I found that the community of the accused is mentioned in the FIR, indirectly suggesting that the accused belonged to a community which was described as a criminal tribe. I must compliment young people who are associated with the Criminal Justice and Police Accountability Project. What I liked was the motto of the project: justice begins where inequality ends. This motto will compel those who are associated with justice delivery system in our country to introspect on the question whether after 75 years of existence of our constitution, are we able to render real justice? Your website also mentions that communities which were previously officially criminalized under colonial laws and are now classified as denotified tribes or Vimukta Jatis are still persecuted and stigmatized. The very noble object of the project is to bring to an end casteist policing and criminalization of marginalized communities by the criminal legal system. All members of the legal fraternity must support this initiative by the project. Though 1871 and two subsequent legislations may have been repealed, the stamp of criminality put on a large number of communities has not disappeared. Most of the members of the denotified tribes are still socially and economically backward. Therefore, when they suffer injustice at the hands of the law enforcing machinery, they find it difficult to get access to justice. Many of them suffer silently at the hands of law enforcing machinery only because of the stamp put by 1871 and subsequent enactments. The Habitual Offenders Act in force in some of the states have created more issues. Thus, I can say that wounds made by 1871 Act and its successive legislations have not been completely healed. There will be, of course, few who will disagree with this comment, but I am sure that even those who will disagree will not be in position to deny that at least the scars of injustice and injuries which have remained, which continue to affect and deprive these communities of the right to live with dignity, which is guaranteed under Article 21 of the Constitution of India. The basic tenet of our criminal jurisprudence, which we have adopted, is that every person who is accused of commission of a crime is presumed to be innocent till his guilt is established before a competent court beyond a reasonable doubt. The presumption of innocence can be traced to Article 21 of the Constitution of India, which guarantees personal liberty. There are exceptions created to this rule of presumption of innocence by some of the special legislations. But in case of majority of criminal legislations, the presumption of innocence continues to hold good. There is a tendency on the part of the law enforcing machinery to detain a person as an under trial for a long time. Marginalized sections of the society targeted by law enforcement agencies and law enforcement machinery do not greatly benefit from the presumption of innocence. The main reason is that they find it difficult to take recourse to available legal remedies. Therefore, the first step which should be taken by those who are associated with the justice delivery system is to open the doors of the courts to these marginalized communities in its true sense. It will enable them to easily access to the legal remedies. The task has to be undertaken by the legal services authorities, rather a network of the legal services authorities which is established under the Legal Services Authorities Act 1987. Even the state has the responsibility to ensure that marginalized sections of the society are provided smooth access to justice. There is a need to sensitize our police machinery through our police training institutes. We must sensitize members of our judiciary on this issue through our judicial academies. The functioning of the courts at various levels in independent India has generated a huge amount of data. I am not an expert on the subject of data analysis. As a judge of 3 constitutional courts for more than 21 years, I was lucky to get an opportunity to deal with very large number of criminal matters. From my experience, what I learned is that criminality or criminal tendencies have nothing to do with religion, caste, or creed of any human being. Proper analysis of data of convictions in criminal cases in our country will definitely prove the hypothesis just now I told you. The hypothesis, I repeat, is that criminality or criminal tendencies have nothing to do with religion, caste, or creed of any human being. Branding a community as a community of criminals is completely unconstitutional, being violative of Articles 14, 15, and 21 of the Constitution of India. Unfortunately, even as of today, there is an attempt on the part of many to brand certain marginalized sections of society as criminals. Due to this tendency, we are creating a situation in which those who are not criminals and those who do not intend to do crimes will be forced to do something illegal only for their survival. Our constitution will be 75 years old on 26th of January 2025. Now the time has come to tell everyone to abide by the fundamental duty under the Constitution of India, which is provided in Clause A of Article 51A. The fundamental duty is to abide by the Constitution and respect its ideals. It is not necessary for anyone of us to read the entire Constitution consisting of 395 articles and 12 schedules to understand what are the ideals of our Constitution. Anyone will understand what the ideals are by only reading the preamble to the Constitution. It tells us everything. The ideals of our Constitution are justice, social, economic, and political, equality of status, and dignity of individuals. Even to think that a particular community is a community of criminals is completely contrary to the ideals propagated by our Constitution. We need to create a very robust mechanism under which data is generated on public domain regarding arrests of persons belonging to marginalized communities, and especially those communities which were branded under these draconian laws of 1871, 1911, and 1924 as criminals. This will enable the NGOs and the legal services authorities to immediately reach the affected persons to render legal aid to them. No member of any such community should be permitted to languish in jail only because the stamp put on the community to which he belongs. The aim of the Constitution is to provide social, economic, and political justice to all. Therefore, the injustice done to these communities in the British regime can be redeemed only if we are able to render economic justice to these communities by ensuring that they do not remain economically backward. They will get social justice only if stigma attached to their community completely goes and is completely wiped out. After I accepted invitation to deliver the Vimukta Diwas lecture, I also started introspecting. I realized that when the legislature comes out with a draconian law, the damage done by the law cannot be repaired for years. Even though more than 70 years have elapsed from the date of repeal of the draconian acts, its adverse effects continue to haunt us every day. This is a lesson which we have learned in independent India. Therefore, those who believe in constitutional ideals must always be on vigil, and they should always make sustained efforts to ensure that our legislature does not come out with any draconian law. The reason is the lesson which I learned in hard way. after effects of any draconian law continue for years. For generations after generations, members of certain marginalized communities who were victims of 1871 Act continue to suffer from the after effects of the laws. After assessing the activities of the Criminal Justice and Police Accountability Project, I realized the importance of work done by these young people who are associated with the project. These are the persons who have really understood that in independent India, as Dr. B.R. Ambedkar said, our battle is for freedom and for reclamation of human personality. The duty to uphold the ideals of our constitution can be fulfilled only if the citizens start openly talking in a peaceful and dignified manner about what is wrong and what is right. If our constitution is to survive, if our democracy is to survive, we need a large number of young people who will stand by the constitutional ideals and work with the same spirit with which volunteers of this project are discharging their duties. No one can say that our courts are not capable of rendering justice. But we must remember that our constitutional scheme and importance given under the Constitution to the freedom of individuals, there cannot be any inequality when it comes to access to justice. It cannot be that few are more privileged when it comes to getting access to justice. We need to do a lot of work in this area. As I said earlier, we need to work for the betterment of the marginalized communities which were branded as criminals under the British regime. We need to ensure that they get access to justice very effectively and promptly. I thank the organizers for giving me this opportunity to have this dialogue. These young people are working with a dream in their minds. The dream is to create a modern India contemplated by Dr. Babasaheb Ambedkar. I hope and trust that they'll be able to fulfill their dreams. I again thank the organizers for giving me this opportunity to interact on the subject, and I wish a great success to their activities. Thank you.
Aditya?
Thank you, sir. I'm Aditya Rawat, Research Associate at CPA Project, and on behalf of the entire team, I extend our sincere gratitude to Honorable Justice Abhay.S. for today's keynote address. We sincerely appreciate your participation in today's lecture, where you highlighted the crucial issues concerning our constitution as well as the Vimukta communities in our country. Your insights have greatly enhanced our understanding of the challenges faced by the Vimukta communities, and the historical context you provided about the colonial inception of the draconian and now repealed Criminal Tribes Act was eye-opening, and how these colonial instruments still impact criminalization of so many in the country is extremely concerning. Your suggestions of a data-driven approach to solving the issues of criminalization of marginalized communities is something we here at CPA also really appreciate. So thanks a lot, sir, for your kind words at the end. And we also would like to extend our heartfelt thanks to Rashid sir and the LiveLaw team for their collaboration. The video recording of today's lecture will be available on their YouTube channel. We're also grateful to everyone who joined us today, as your presence and engagement is highly appreciated. Also, in order to access the transcript of the entire lecture and to know more about our work, you can visit our organization's website at cpaproject.in. As we observe Vimukta Diwas, let it serve as a powerful reminder of our ongoing commitment to dismantling discriminatory laws and practices that continue to infringe on the rights of individuals and communities. This day is not just a reflection on the past, but a call to action, urging us to work towards a more just and equitable society, where every individual is free from the shadows of injustice and prejudice. Thank you all for being part of this online event. Your continued support and commitment are vital to our mission of promoting justice, equality, and freedom for all. We wish you all a meaningful and revolutionary Vimukta Diwas. Jai Bhim, Jai Savitri. Thank you.
Thank you so much, sir, for being here. Yeah,
Thank you so much, sir.
I think we can end the live stream. But thank you so much for being here and deliver this keynote address for us. It was really engaging for us as well, and also for our work as well to be in such a panel and to hear your views about our work as well.
I'll always look forward to support you.
Sir?
I will always look forward to support you and your activities.
Thank you, sir.
Right.
Thank you.
So much, sir.
Thank you. Thank you.
Thank you, sir.